we'll just keep an eye out, keep adding people as we go. Wanted to welcome all of you to our session this afternoon on Harry Potter and library law. You have already some descriptions of our participants this afternoon. I just wanted to let you know how I came to know each of them. David Hogue was the county attorney for Faulkner County when I first moved to Arkansas from Texas, and I was still catching up on the difference in what the state laws were in the different states. And David was just an invaluable resource. Anytime I had questions about my library meeting rooms or anything else that came up, he was just great for letting me know exactly how we needed to handle that, and was always a big library supporter. Where I actually heard of Brian first was a book that I just learned about a few months ago, and I'm putting a link for that in the chat for you here. Brian actually wrote a book about the case that we're discussing this afternoon, and I found it very interesting. But one of the things I found most interesting was to discover that my friend David was included in this book as one of the attorneys involved. And I thought, okay, we have the makings of a great webinar there. I would really like to hear both of these gentlemen discuss both sides. There's David showing his signed copy of the book. So, anyway, I'm really happy to have both of them here this afternoon, because one of the things that's interesting about this is that even though they each debated one particular side of the case or presented that, litigated that in court, they each have said they understand the other side too. These things are never black and white. And since this, they've had a lot of time to think about the case and things that they might have said differently if they could have at the time, or things that they've thought. So their ideas may have changed since then. Things are never black and white. And so I think, you know, both attorneys see both sides of this case, and I'm going to let them take it from there to tell you exactly what those sides were and what implications that may still have for us. This case may have settled some questions, but there's still plenty of other questions not entirely settled that we might want to be aware could come up at some point. So Brian and David.
Okay.
Since it's Brian's PowerPoint, I'll let him go first, and then I'll rudely interrupt once in a while.
I love it. I was wondering how we were going to do that.
Yeah,
First of all, I'd like to thank everybody for joining us this afternoon, and I am particularly flattered that you're joining us this afternoon when the impeachment hearings are going on, because at the risk of being political, that is the best stuff on television right now. It's, for those of you that ever want to see a really good case put together, watch that. It's really good. But thank you for being here. My name is Brian Metters. I was the plaintiff's attorney in the Harry Potter case, and we'll get to that here in a little bit. David, if you'll introduce yourself.
Yes, my name is David Hogue, and I was the respondent's attorney in the Harry Potter case, which means I represented the school that was promoting on my side, we don't want to call it censorship so much as protection of children from evil materials. And so I represented the school in doing that.
Dave and I first met on the Harry Potter case, and we actually became friends as a result, even though our clients were most certainly not friends. All right. So what we're going to do first, I want to talk about the actual scope of the presentation. Brief background: 2003, Arkansas School Board banned, or as David said, restricted, if you want to be technical, because they were protecting children from dangerous books, Harry Potter books from the library. On behalf of their 4th grade daughter, parents brought suit to have the books returned to the shelves. David, you want to take the rest of the slide?
So where this started is there was a, well, I guess it was all the Harry Potter books at the time, wasn't it? Or did we just have a few?
I think there was only 4 that were out at that time, 3 or 4.
Yeah, so I think I remember 3 specifically, but we had the 3 books on the shelves, and the school had determined, based on some wishes of some other parents, the school had determined that the Harry Potter books were pollution for children's brains, that they taught Wicca, they taught witchcraft, they taught all things evil. And so because of that, the Cedarville School Board voted at the request of some parents, but the Cedarville School Board voted to remove the Harry Potter books from the public shelves where all the kids could get to them, and put them behind the library's desk, the librarian's desk, where the children could only get to those books if and when they had a parent's permission slip.
So right, and so let me stop you
Go
right
ahead.
there, because we're going to get to a little bit that more. So,
Yeah.
so thank you. Right, and so on this presentation, when we were preparing this presentation, we wanted to try to limit the scope a little bit,
Right.
because there's so much here, especially the way of First Amendment. So we're going to limit this presentation to the history and the current status of the legal doctrine regarding the application of the First Amendments to books that are already in the school library's collection. And you'll see later that becomes a critical distinction.
Right.
We're also going to limit this presentation to the facts of this case. If you have, and I'm sure we will get in the chats, and Tina, my understanding, may occasionally chime in to help us with chat questions. We're happy to try to answer hypotheticals, but they're hypotheticals. And then we also want to try to give some sort of guidance to the role of the librarians who are facing books challenges. And my understanding is a substantial portion of this audience either has been in that position or aspires to be in that position upon graduating. All right. So David brought this up earlier.
Yes.
There's a Cedarville pastor named Mark Hodges. Cedarville is a small town, really village is probably the better word, in Arkansas. And on Wednesday nights, like most Arkansas churches, there was a Wednesday night program. He preached against Harry Potter. David, I think you already covered exactly why Harry Potter is bad. Because it's Wiccanism.
Just a minute portion of why Harry Potter is bad. Go ahead.
Yes. Promotes witchcraft and therefore harms children. And so a woman named Angie Haney, who actually I get along with now, although I first met her in response to my subpoena, lodged a complaint at the behest of her pastor about the book with the school librarian, Estella Roberts. Now, I want to interrupt briefly, and I want to give you all a little bit of legal background about how students get First Amendment rights. Up until the Second World War, the courts did not apply the First Amendment to public schools. They deferred to school boards. They believed in the important values or the importance of local values and control. And there was also a real hostility in a lot of areas of the country to unpopular religious sects. And so this is actually how we got the cases that gave the control to the school boards, because the Jehovah's Witnesses were forever stirring up trouble in the eyes of Protestant Americans, and that they refused to salute the flag and so forth. But that didn't last long. David, talk about what killed how the Jehovah's Witnesses killed the idea that school boards and schools should be exempt from the First Amendment.
Am I just reading from your slide here?
A bit of it. All right, a little bit.
Why don't you do that?
I'll do that. So
I'll come in.
All right. So yeah, we'll do it that way.
Yeah.
I'll take the lead, and then you chime in and correct me or
Yes.
steer me in a different direction.
Absolutely.
Okay. So the Minersville case gave rise to happened where several Jehovah's Witnesses were being punished for refusing to salute the flag. And at that time in U.S. history, discriminating against and disparaging minority or fringe views of people was perfectly acceptable in the culture. And Jehovah's Witnesses were a frequent target, sometimes with violence. So in 1943, with the fighting of the Nazis going on in that political backdrop, the Minersville case, which allowed the schools to basically force children to salute the flag, ended up getting reversed because nationalism had taken a back burner, and they said that you can't, there are some First Amendment protections, and if a student doesn't want to say the pledge, he or she doesn't have to say the pledge. All right, let's go back to the main story. Estella Roberts gets the complaint. And her first step, and this is my counsel to all the future librarians here and current ones, is you contact the American Library Association. And my understanding is that each one of the states have their own library association, and you should do that. And they told her to follow their response packet. And they have essentially a procedure that you follow. And you begin with the challenge process. And the challenge process, at least in this case, was 5 folks. I believe it was a teacher, a parent, a student, and then there were 2 others. David, do you remember what they were?
I don't remember who they were. No, sorry.
I will tell you now, and I'm sure David guessed this during the case. Estella Roberts chose people who she knew would be favorable to her viewpoint. So librarians, that's a little trick you've got whenever you set up the response to this.
Of course, it's like picking a jury.
Yes, you get to pick your own jury. So when this challenge came in, she picked the challenge process, or she picked the folks who would be on the committee. It was about 15 people total, 1 from elementary, 1 from junior high, 1 from high school. All right, let's go back to the law real quick. Because what I'm showing here is how the law evolved over time. So remember, I can't force students to do a pledge, but basically besides that, they don't have any other rights. Fast forward to 1965, students start wearing black armbands to protest the Vietnam War. And the school took the position, students don't have rights to do that, and we can tell them what to do. And the Supreme Court ultimately disagreed, and they said, we have a tension here. There's a tension between the school being able to run affairs as they see fit and promote their values versus however many First Amendment rights that the students actually have. And so Tinker set up a framework for that. First question, is this free speech? And if it is free speech, is it disruptive? And the disruption portion is critical, as we'll see in later cases. The Tinker family won because the school had admitted no disruption. It was merely the wearing of armbands. And for that reason, that was allowed. So that's another chink in the armor of school boards where the students get a little bit more protection than what they had. All right, let's go back to the story.
Okay, before we go back to the story.
Yes, sir.
I wish I could see the audience here, but we'll make it kind of like a discussion between me and Brian. Before all of the Tinker stuff happened, and in 1965, we go back to the 14th Amendment. If we go all the way back to the 14th Amendment, we have some magic language. And when I say magic, I mean magic because it's in the Constitution. I'm trying to get my screen to work here. Hold on. We have the 14th Amendment that says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person or life, liberty or property without due process of law. So why is that relevant? It's relevant because there are 2 sets of people here. One is the parents and one are the students who have these rights of 14th Amendment. Under the 14th Amendment, both sides have a right to free speech. Both sides have a right, the parents have a right to free speech and to control their children's education, and the children have a right to free speech. So what we've got and what Brian just introduced is the clash of a few constitutional rights. Now, if you've ever watched a horror movie, a scary movie, you'll remember that there's always a time that the people sitting in the living room watching the movie or the movie theater will say, don't go into the basement. And if the people in the movie would just take the good advice of not going into the basement or not going into the back shed or up the stairs into the attic, the whole movie would be over, right? Because they made a good decision. If this whole case would have been over very quickly, and heaven forbid we want that, but this whole case would have been over very quickly had we talked about a case called Pierce versus Society of Sisters in 1925, which came before Tinker, but Pierce versus Society of Sisters established the point that yes, the parents have these rights to control their children's education, but not so far as as to control what's going on in a public school. What happened in Cedarville versus Harry Potter, the Cedarville case, is that the parents were trying to control their children's education through the school board, but it was a public school. And the only way a parent can actually control the education of their children in public schools is to pull them out of the public schools. Otherwise, it's a public organization that is controlled by the public. Now, with that said, let's go forward from Tinker and recognize that the root of this whole issue is bigger than Tinker, but it's also pretty well established, which obviously we all knew going into it, but we had a case to make. Go ahead, Brian.
Okay. The library committee of those 15 folks reviews the Harry Potter books. They come out 15-0, but again, to be fair, the librarian stacked the jury. I don't fault her for that. I think that was a good idea.
No.
Came out 15-0 in favor of the books. School board, in a very lively and energized discussion, votes 3-2. First of all, when they first got it, they actually just tabled it because all the news folks were outside, incomplete with the vans with the giant soda straw, tall antenna, and so forth. This is pre-internet days, so everybody still watched television back then. So they tabled it until the next meeting. And the next meeting they got together, and then there was a 3-2 vote to remove the books from the shelves, but they didn't ban them. I talk about this as a ban, and I use the word censor, but the fact is that they were just restricted, and they were put near the librarians' desks, and the students had to have a permission slip to be able to access the books. And then the books were also removed from the accelerated reader list, which is arguably part of the criticism or part of the curriculum. When I took this case, I just remained silent about that because I didn't want to raise that because that was not going to be in my favor. School has the ability to control their curriculum. So I just stayed quiet about the whole accelerated reader thing.
That would have been a big point for me too, and you did well to remove it.
So sometimes it's just, and it's taken me over 50 years to learn this lesson, but sometimes it's better to just say nothing.
The fact that Brian had the good judgment to remove that from the curriculum argument has everything to do with what I just said. The parents have some rights of controlling their kids' education. And so they do have some rights about the curriculum, and the school board has some rights about the curriculum. But if you remove if we're not talking about the curriculum, then we're back into the area of free speech and not 14th Amendment. So we have a different game to play, and Brian was smart enough to make sure that he put his game on the field where it needed to be.
Right, you're right. Right. The winning field for me was the library. It wasn't the curriculum, especially with the federal judges we had at that time.
Yeah.
In the Western District. All right, legal background. This is a fun case. Hey, David, for my book, I actually talked to one of the plaintiffs for this.
Did you really?
I did. Yeah, I still remembers it. So, Levittown, New York, 1975. There are school board members in a very conservative Long Island suburb. This is actually, by the way, one of those suburbs that was first created with the restrictive covenants that would only allow white people to live there.
That's interesting.
So that should give you a flavor of the kind of place we're talking about. So
but it was in New York.
Say again?
But it was in New York.
Yeah, isn't that odd? Yeah, no, Long Island hosted that. It was one of those post-war developments.
Yeah.
So the school board members were hosted by the ultra-conservative John Birch Society, which was a lot more active in the 70s than it is today. And they John Birch Society had a list of offending books. And so literally in the dark of the night, these school board members go into the library and they pull out the books out of the library. So the students, and they would describe themselves frankly as hippies or aspiring hippies, got together with the ACLU and they challenged the ban. And that wound its way up through the courts. And then ultimately the US Supreme Court ruled in favor of the students. It's not a clear win. So they had 3 + 1 + 1 versus 4. So we always hear about a Supreme Court decision and we assume that the majority speaks with a unified voice. That's not always true. Sometimes you just cobble together different votes who will vote the way, vote in favor of you, but for totally different reasons. And that's what happened here. So I had this case out there that would apply student free speech rights to include the school library, right? I know that my students can wear armbands. I know that they can't be made to wear the flag, but do I have a case out there where I can apply the First Amendment to the school library? Well, PICO was that case. And at first I was pretty excited. And then I saw that we had a plurality and I thought, man, that's not going to be enough, right? Like that's not binding precedent.
For those of you who don't know the case well, it was a case that would remind you of Fahrenheit 451 if you've read that one.
Yes, it was. Yeah. Okay, I'll move on. I'm trying to be balanced over here. Okay.
Good luck.
So on July 3rd of 2003. Dakota Counts, who is then in the 4th grade. She's now an accomplished young woman who's living on her own, and I think she works for some large corporation somewhere. Actually, I have some contact with them, David. Whenever I was purchasing the rights for the book, in order to get a waiver of attorney-client privilege, I offered them 20% of the royalty. Yeah. So I cut them a check. I cut them a check every so often for the 20%.
Well, if you ever see her, tell her I said hello.
I certainly will. That's right. David deposed her.
It was fun.
Yeah, you did a good job. So they walk into my office and they want to sue the school district, and I couldn't sign them up fast enough. So I filed in federal court because those judges aren't elected, and I didn't want to file it in Crawford County, which is a pretty conservative electorate. And I didn't have a lot of confidence that some of the judges that I might pull would be very friendly to this case. So I filed it in federal court. It was a federal claim, so that's perfectly legit. The media picked up the story, and free speech groups contacted me and joined in the fight. David, I don't know if you know this or not. They were slipping me cases on the side, helping direct me. That Sund case that I found, which we'll talk about in a bit, I got that. Yes. I got that from the ACLU lawyers.
That's funny. Just a side note here, and hopefully I won't take us on side notes too much. I've been in your position when gay marriage came up in Faulkner County, and I was the guy getting notes from national organizations on the other side of the case, of course. But yeah, I know the pleasure of that. It's nice not to have to write all your own stuff.
Yes.
Go ahead.
All right. Now, we've already established that students have some First Amendment rights. We know that they can exercise those First Amendment rights as long as they're not disruptive. I know that I kind of sort of have a Supreme Court case that says that those rights can be exercised in a library. Now, what does it mean to censor a book? If I hide the book or I restrict it or make someone have parental permission to get it, is that the same thing as censorship? Is that really an infringement on the First Amendment? So enter the Sund versus City of Wichita Falls case. And this is the one that Dan Mock of the ACLU, he was then with Jenner and Block, but now he's with the ACLU, gave to me. He called me up. So in 1997, Wichita Falls, Texas, which is a very conservative red state kind of place, that public library purchased 2 LGBTQ friendly books. Heather Has Two Mommies and Daddy's Roommate. They're highly acclaimed, highly reviewed, well-reviewed books. And just as an aside, I'm sure the audience knows this better than I do, but it's my understanding that there's a great deal of importance in having children's books where the children can identify with the characters. So this is why it's important to have books that feature minorities or feature children with non-traditional households. So towards that end, this librarian got these 2 books. So there's a local mega church pastor. I'm going to call him out. His name was Robert Jeffress. And I know that he then later moved on to Dallas, and then he later became one of the evangelical advisors to Trump. But at this time, he was still in Wichita Falls, Texas. And he criticized the books on his TV show. And a petition to the city council was made, and it resulted in the books being relocated to the adult section of the library. And the way that it was relocated to the adult section of the library is that there was a city council ordinance that was passed that said, well, if a few hundred people object to a book, then we can just move it over to the adult section, which essentially gave those few hundred people what's known as a heckler's veto. If a few people protest it, they can keep it away from thousands of others. So future librarians and current librarians, that's what's at stake here. Whenever you start giving in to people's demands about what can and cannot be seen or reviewed or read in that library, you're giving a heckler's veto, because if you start pulling everything that offends everybody, you're soon going to have nothing. Federal court got a hold of the case, found that moving the books to make them less accessible improperly infringed the children's First Amendment rights. This case was not binding on the district that I was in. Pardon me. This case was at a district court level. It was in the Northern District of Texas. I'd brought the case in the Western District of Arkansas. This is what's considered in the law as persuasive authority, but not binding authority. Nevertheless, because it was a well-reasoned case and the facts almost exactly matched, I relied heavily on this case whenever I wrote my brief. Back to the story. So after I get hired, I serve the complaint. David answers the complaint. David's letterhead and his envelopes at that time included the, am I saying it right? Ichthus?
Yes, very good. Ichthus.
I remember my confirmation classes. I saw that. I saw that on the envelopes when your answer came in that case, and I thought, oh my goodness, what am I in for here? And the name of his firm was Christian Legal Services, and I was pleasantly surprised that I got an answer as opposed to a motion to dismiss, so I didn't have to run through all of that, which made me happy. And so then we began the discovery, and we exchanged documents, and we also interviewed witnesses. David, you want to talk about your witnesses first or mine?
I don't remember the witnesses all that well, but let's talk about Pastor Hodges. Let's just go there real quick.
Yes.
And Pastor Hodges gave kind of the classic testimony, which is what got me into the case, that that magic is real. Okay, so there's all sorts of, like I said a minute ago, there's all sorts of root issues underneath this case that we never really get into in the case, because one side or the other knows not to get into that issue because it'll screw up the case, and that's the magic. But pun intended. Pastor Hodges was testifying that there are schools.
We should pause real here. Pastor Hodges also happened to be on the school board, and
right,
he was the chairman of the school board, and so he was one of the three to two that voted to restrict the book. Sorry, we should have said that earlier. Yeah, go ahead.
Yeah, and on that point, by the way, if you remember the school board meeting where the media was all there and they decided to table it, that's because they had an attorney off camera in the background saying, table this issue while the media is here. Do not take it up right now. Do it at a special called meeting that not all the public and press will know about and be able to get to that quickly. So there's always magic going on behind the scenes.
I didn't know that. Was that the usual school board lawyer that did that?
No.
Is that you?
It was me.
Okay, keep going. All right.
Yeah. So what we have is Pastor Hodges is a fairly fundamentalist pastor who says magic is real, and Harry Potter is using elements of real magic, and the threat of magic is real, and he had the school board pretty convinced that this wasn't, as some people pointed out, this wasn't your average Disney story where there's a wizard or a warlock or a magic sorcerer or something like that. This was much more real than that, and actually incorporated matters of Satanism or Wicca or other things in.
So yeah, so actually, let me say this. This is one of the things I learned in the course of this case that I had not realized, is just how much J.K. Rowling was trolling the evangelical community when she wrote these books.
Oh,
She
yeah.
cited the names of actual historical figures who claim to be magic and do magic spells and so forth. And those are the same names of a lot of the characters that are in there. I think Flamel, Flamel,
Oh, yeah.
is one of
Yeah.
those. And some of the spells that she uses are taken from the pages of these medieval tomes. And so for the folks that give credence to that, these books were all kinds of red flags to them. It wasn't just
Absolutely.
made up Disney stuff.
And one of the things that you mentioned in your book about me is that I studied witchcraft, and I studied Wicca, and I studied demonology, and I studied all sorts of stuff when I was in college. And so I was coming in with a knowledge of Wicca and witchcraft and so forth. And so on one hand, I knew that Pastor Hodges was off base when he said how realistic this was. But on the other hand, I also knew that J.K. Rowling had done her homework to make this sound as realistic as possible when she wrote the book, which now I have great respect for. But anyway, you can take the next witness.
Yes. So that was Pastor Hodges. And I essentially used the Sund case and the Tinker case and so on as my guidelines to make sure was, to get him to admit there was no disruption, get him to admit that, well, first of all, there was no disruption. And then I also had to get him to admit that he was solely religiously motivated. And I mean, I'm a pretty obnoxious guy, and I was really obnoxious at that time in my life. And so, and you can really pull that straight out of the depositions if you read it, right? It was, right. He laughs because he knows how true that is.
You're a jackass.
So in the guilty. So
Yeah.
So in the depositions, I would ask these quite snarky questions. Say, well, instead of Harry Potter and the Sorcerer's Stone, what if it was Harry Potter and the Communion Cup, and instead of celebrating witchcraft, it celebrated Christianity? Would that be okay with you? And so, of course, they all say yes. Yeah, that'd be fine.
Which was it was a sow bug to a trout right there. I mean, that was a good question, and they just bit, and I wanted to slap them under the table when they bit, but they still bit. Go ahead.
Yeah. To your credit, you behaved ethically in the case, and I appreciate that.
Thank you.
So the depositions, I felt won that. Now, there are a couple other parts of here in the witnesses. David interviewed my client and brought out the fact that she had full access to the books, and her parents let her read them all the time. And David asks, and we'll talk about this in a little bit, so how does this even affect you? Like, do you really have standing in this case? This isn't even affect you because you can read these books at any time. And then I'd also brought suit on behalf of the father, and he was totally unaffected by the whole thing. So what business does he have bringing suit? And it was very effective questioning by David. And then I'd also say again.
Just for a second, let's this is where I would look at the audience and say, okay, who understands what standing is? And since I can't really do that here, let's talk about standing for just a second.
Yeah, that's a good point.
Standing is the if there's a two-car accident and a third car sees it, the third car doesn't have standing to sue about the accident's damage to the one of the two cars. Make sense? I don't have standing to complain about Trump's impeachment trial, for example. I'm not a party to the case. I'm not injured by the situation. If you're not injured and you're not a party, and the directive of the court or the ruling will not affect your rights in any way, then you don't have standing. And so one of the things I was trying to do to Brian's case was make sure that that the two plaintiffs had standing, or more importantly, did not have standing, by showing that that the child still had access to the books in other places, and the dad didn't matter whether he had access to the books or not. That all comes back to the right of the parents to control the child's education, because in a public school, there used to be, back in '94, there was a strong case, and we didn't talk about this in the case because Brian wisely didn't go into the curriculum issue. Back in 1994, there was a case where some parents objected to the teaching of Wicca in a public school. And they did so on the idea that I said earlier, that we have a right as parents to have some say in our child's curriculum, in our child's education. The answer to that is all about standing, because when you try that, the response from the school would be, yes, of course you have rights to control your child's education, and if you want to do that, you can go to another school. Likewise here, I was saying, yes, you have a right to read that book, and if you want to do so, you can go to a public library. The problem is that this is a public library in the school, and that's a big key in the case. Go ahead.
Okay, yes. All right. I had a witness named Louise Turner, who is a gentle soul and had been a librarian for 30 years. She had decades
Very
of
wise.
experience. And she was a librarian when I was growing up. She talked about how children's books should be age appropriate, which is a rather fluid concept that David grilled her about during the deposition. She talked about the importance of how books should be open and available to browsing patrons. If you put a book and you secret it away somewhere, or you put it like behind a shelf and make people ask for it, folks are less likely to come across it naturally. She also talked about how fantasy and imagination are critical parts of children's literature. And she also talked about how Harry Potter, among all the series, had excited children to read in a way that no other book series ever had in her career. The age appropriateness concept is a sticky concept, because at what point are we just censoring, and at what point are we saying that something isn't age appropriate? And you had her on the ropes, frankly, in that deposition on that.
If I deposed her today, we would be talking about age appropriateness again, and the fact that the Harry Potter books grow darker as we go through them. And
Yeah.
so, but it doesn't make a whole lot of sense to me, morally or literarily, I'm an English major after all, to say that you can read the first Harry Potter book, but then kill students in the fact that you can't read the rest. So there is an age appropriate argument that I could make, but it would have been suicide to try to make it. Because when you get down to the Death Eaters and Voldemort at the end and all this kind of stuff, it's a little less age appropriate. But the way J.K. Rowling did this whole thing is it was age appropriate with her initial audience, and they grew with the books as the books grew with them. So that's the genius of J.K. Rowling. Go ahead.
Yeah, one of the many. Yes. Okay, so after all the depositions and the discovery and so on, we have transcripts. Nobody really disputes what the facts are. You only go to trial if people are arguing if it's a he said, she said. So in this case, we were going to resolve this on summary judgment. So I had that pico plurality that would allow me to apply the First Amendment in the library, kinda. So I had to see, does that apply in Arkansas? So in fact, it did. There's an Eighth Circuit case. That's what Circuit Arkansas was the Eighth Circuit. And it happened in a case called Bystrom v. Fridley High School. And in this case, a bunch of high school students who are my age, I mean, when they were in high school, they had an underground newspaper that was filled with profanity and juvenile sexual comments. The school censored the paper, the students sued, and the students ultimately lost, because at that point, the school started getting wise enough to always allege disruption anytime that they could. And so in this case, because of the students were a titter about the contents of the newspapers, the school found disruption and the courts agreed. And so the newspaper was allowed to be censored. Now, having said that, that Eighth Circuit opinion, the appellate opinion, I don't normally like to rely on cases that don't go the way that I'm arguing it for, but it had really good language, and a lot of that language was almost apologetic in how they and how they came to their decision, complete with the caveat of, we're not saying this is good policy, we're just applying the law. And they walk through all the different categories of speech which would allow a book to be properly censored out of the school and by extension the library. And they relied on PICO in doing that. So that makes PICO good law for me. And it also gave me a whole category of cases, several categories. So in my depositions, I would say, is this profane? Is this obscene? Does this promote the use of alcohol? Is this too sexual, and so on? And of course, the answers to all of those are no. And I was just ticking boxes on this Bystrom case when I did that.
There was that episode where Potter drank the butterbeer in the village when he escaped from the school. I mean, you know, we should kick him out for that.
Just kick him out for that.
Yeah.
All right, so we have summary judgment. There was no disagreement about the facts. I argue that it's free speech, books aren't harmful, no disruption. Several of anti-censorship folks all got together, including children's author Judy Bloom, and they filed, if it were just one person, it'd be an amicus brief. There were multiple folks here, so it'd be an amici brief in Dakota's favor. David, talk about your arguments.
Okay, so we come back to the idea that that because Dakota has access to the books, Dakota doesn't have standing. Here's the thing, and Brian, I'm sure could figure this out, but we've never talked about it before right now. I knew then and I know now that there was the 1920 case out there that was against me. There was the whatever it was I just said, 19 something case about the Wicca thing, 85 it looks like, Grove versus Middle School. And there's lots of cases out there that made it clear that that the standing issue is for the parents, if I can't control my students' education here, then you can go elsewhere. So my argument, the best argument I had, because I knew that the school really didn't have standing to do what we were doing. So I knew that my argument was really weak on the curriculum as well as the free speech issue, which we need to explain how reading a book is free speech. But the best argument I felt like I had was that Dakota did not have standing because she has the books at home. She can get them in the public library. She's not harmed because she didn't have the books. And the father likewise is not affected because he can get the books anywhere. That's basically, for what it's worth, the same argument that the conservative side of the case uses on baking the cake for the gay wedding. It's that same argument. So Brian, how do you deal with that argument that people who can get it anywhere else are not harmed by the fact that they can't get it in this one place?
Right. It was an argument that I had a lot to worry about. I'll tell you, when it came to the father, David won it on that point. The judge dismissed the father out of the case.
Sure.
The judge did find that Dakota's harm was very slight. However, he also noted that in First Amendment cases, because of the nature of those kinds of cases, you didn't have to have a whole lot of injury. In fact, you just had to have some bare theoretical injury because of the importance of the First Amendment. And that's frankly what saved me here.
Yes.
All right, so yeah, that's the ruling. Judge Roll's father had no standing. He did rule in favor of Dakota, and he ordered the books back on the shelves with no special restrictions. And then the school board then voted 3-2 not to appeal. And then I was able to pick up fees they were pretty modest, somewhere in the order of $13,000.
You weren't in it for the money anyway, were you?
David, I'm afraid I may have had mixed motives.
No.
Am I not supposed to say that? Okay, it was white knight and I was carrying the banner the whole time.
We were both there for the principal. That's what we do as lawyers.
Right. PLE and PAL. Yes.
That's right.
So some open questions. The school returned those to the accelerated reader list, and I never You know, I kept staying quiet about that. If they had kept it off the accelerated reader list, which was part of the curriculum, I'm not sure I could have done anything about that.
I think you could have.
Pardon me.
Because of the cases that I just mentioned, you could have kept it on the curriculum because of these couple of cases I've mentioned that say very clearly, if you don't like the curriculum, you can always go to a private school. I'm glad that you didn't do that, because it would have made, you would have had a better shot with what you did than that. But I think that that when it comes down to it, even the curriculum argument would still win based on the 1920 case, the 1984 case I just brought up.
Okay. So Dave and I have talked about this. So we talked about what happens when the school has those books in the library. And I'll tell you, for the folks who are on school boards, who see it as their mission to properly protect and shape the morals of their students and to have them be consistent with the values of the community as they perceive them, the best bet is to never let those books in the library in the first place. And there's no laws or case law out there that I'm aware of that talks about what librarians must buy or not buy. Are you aware of any, David?
No, not really. I think that in a like I said, there's a big difference between the public venue and the private venue here. In the private venue, the school can do what they want because they're private. In a public venue, the school board has a right to let a librarian go in, say, an employment at will state. But they don't have a right to control what the librarian buys and doesn't buy. So it's much like a legislative body has the right to control a budget, but they don't necessarily have a right to control what the state agency does with the budget they create.
Right, I can see that. I will say this to the librarian folks: if there is a book that you think is going to be a problem and you really want to get it, I would advise that you get forgiveness and not permission.
Amen.
Yeah. All right. So number 3, the third bullet. This is where I want to make a caution. When I wrote the book about this case, I did not demonize the pastor, nor did I demonize the woman who Angie Haney, who brought the complaint. And the reason that I didn't is because while I have a fundamentally different view of the universe than they do, their hearts are in the right place. And they really believed that what they were doing was promoting and protecting important values. And so it brings up a question about local control and about what kinds of values do we want and how do we want that communicated in our schools. And give an example of this, let's just flip the script. Let's say that we have a school, that's, well, I'll just stop there. It's to me, it is not a clear question of, there is an argument to be made that schools should be able to have some control over what they teach and how they teach and what's available to students. There is an argument to be made for that. It is not frivolous.
I think on that point, and I'm known for my my pushing the envelope on some things like this. So on that point, if you take a town that would be, and I'm just going to make up a hypothetical town. If you take a town that would say be known nationwide and maybe worldwide for being a racist town, maybe the headquarters of the Ku Klux Klan and they wanted to put books that were all white nationalism in their library, the town could do that. And they can't be compelled to respect all viewpoints, including disfavored viewpoints, but that would be a bad decision for the library. They can do that and buy the books that they want and not buy the books that they don't want. But once a book is in there, that's a different issue. And that's what this case is about, not the buying of books and putting them in, but the censorship of books once they are in.
Right. Yeah, it's an important distinction. Okay. Whoop. There we go. All right, so that's, yep, thank you very much. I appreciate all that. So that's where we are. I'll stop my screen share.
Tina?
Yeah, okay. We just have a few minutes, but if you'd like to ask questions, feel free to unmute, turn on your camera if you'd like and raise those questions, or if you would prefer, you could put those questions in the chat and I'll try to keep an eye on those. Appreciate very much Brian and David both being here today. This is subject obviously that they've thought long and hard about, and they could both keep you busy with lots of other stories if you had the day to listen.
Yes.
There is a question in the chat. How did the judge decide that Dakota had standing?
The judge determined that Dakota was he actually used an example where perhaps she wanted to stop by the library and pull the Harry Potter book off of the shelf and just kind of flip through and remember a favorite passage. And she was hindered in doing that because instead of being able to just pull it off the shelf, she would have to go find a librarian, have had the permission slip, and ask the librarian to pull the book off of the shelf. That impediment was considered slight enough to give her standing.
Other questions?
In the absence, Tina, of a question on this point, it's a big deal to me to explain this. So where's my share screen? Share. Can you see the First Amendment there?
Yes.
Okay. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press. This is a rather challenging thing to get your head around, and so I'm going to explain how this whole case about a book in a library is about free speech, and then let Brian correct whatever I say. The freedom of speech is not just the freedom to talk. The freedom of speech is the freedom to think. And if someone restricts your access to anything from Little Black Sambo to to Fahrenheit 451 or the Federalist Papers or anything else, then you are not only restricting that person's reading, you're restricting what that person can think about. When you restrict that person's thinking, you are thereby restricting what that person can talk about because you've restricted what they can think about. And so by that fact, and I'm very much simplifying this, by that fact, the Supreme Court has said several times that when you try to restrict what a person can think about, you also restrict what they can say and vice versa. We don't, J.K. Rowling is an example of someone who is in Britain, so we're not really concerned about her freedom of speech because she's in Britain. But we are concerned, and the judge saw this, and Brian saw this, and I saw this, even though I was on the other side. This case had all sorts of implications that if it went the wrong way, all of us would go the wrong way. For example, if the judge didn't say that these books could not be restricted, the next time somebody came along, and this is something I had to explain to my clients, the next time somebody came along that was an atheist, they could put, if a school district, the school board was atheist, they could put the Bible on restriction. Or if they're Christian, they could put the Quran on restriction. That's not the end result that this judge wanted. That's not the end result that I wanted or Brian wanted or anybody in their right mind would want. And so the freedom of speech is the one thing in the First Amendment that we can hang our hats on to keep the freedom of open mind is what that's really about.
Okay, we have a question, a couple of them in the chat. One is, do either of you know whether the school library actually bought the other Harry Potter books after this case was over with? Because the series was not done yet.
I have no idea.
So I'm sorry, say the question again. If other libraries wanted the books after this?
Whether either of you know. Did
Go
Cedarville
ahead.
buy the other 2 books in the series after the case was over with?
I don't know the answer to that, but I'd be willing to bet that they did. You know what? I don't know. The answer is I don't know.
If they didn't, I'll donate them.
Next question is, can a parent ask a school librarian to restrict what their child can check out from the library without it affecting other students being restricted from the same book?
David, I want to say the answer to that is no.
Yeah, the answer to that would have to be no. And that comes down to the same idea that the parent can control their child's education either by putting them in a private school or by teaching the child to restrict the things the child engages in. I mean, you know, children can get their hands on all sorts of stuff, whether anything from tobacco to firearms to anything else. And the obligation of the school is to teach the children, not to teach the children or protect the children from what the parents don't like. If they want to do that with their child, they can teach their child not to do those things, but that's about it.
Okay, other questions? Okay. Well, we appreciate this very much. This session will be available on our, there you go. Thanks for the folks there. You can go to the SLIM website at any time and find links to all of our webinars that have been recorded. Give it a couple of days before that gets posted, because we usually try to just do a quick check of the closed captioning, but watch for that. And then we will also put the PowerPoint
Thank you,
slide
Angel.
up with that. Okay. Any other
That's quite a compliment we got, Brian.
Say again? Oh,
I said that's quite a compliment Miss C.A. Angel just gave us. This is the first Zoom meeting. She's paid attention to the whole thing.
oh, well, thank you. For whatever reason, I can't see the, for whatever reason,
We
I
didn't
can't
put
see the
anybody to
chat.
sleep.
Thank you. Thank you very much.
I think we did have one
There it
other
is.
question just before that. Okay. All right. If you have questions, don't hesitate. We can try to get those questions to these folks, and I'm willing to bet they're both willing to continue to engage on this subject. So feel free to
Certainly.
contact me. I'll put my email in the Zoom in just a second. We had a question about certificates. We don't have that for this, but you can save the chat to show that, you know, you participated in the session today. And again, the session will be online. Okay, thank you very much for participating. We're glad to have you all here today. Here is my email in case you want to get in touch with further questions.
Thanks to all the folks saying the nice things in the chat. I appreciate that.
All right, thanks a lot.
Thanks. Bye-bye.
Bye-bye.
Bye-bye.